Breakout session on digital trade agreements as a strategy for internet governance. We have a tremendous group of panelists here. I'm going to turn to them very shortly. My name is Ted Alden. I'm a senior fellow at the Council on Foreign Relations here in Washington, and for many years was a reporter with various newspapers, most recently the Financial Times, their bureau chief here in Washington. I want to thank Susan very much for inviting me to moderate this important session. I was delighted in part because, candidly, I don't know a great deal about this issue. So this was a great chance for me to learn from some real experts. I come out of the trade policy world, and I must admit there's a tendency for those of us in trade policy who haven't dealt in this issue to look at digital trade as just a kind of another form of trade. So trade agreements are all about breaking down barriers to cross-border commerce. And in theory, that ought to apply to digital trade as well. But as those of you who know a lot more than I do about this issue are aware, it's not as simple as that when it comes to digital trade and internet governance. There are a whole host of issues in this area related especially to privacy and to data security that are really quite different from selling beef or aircraft or auto parts, which is the normal stuff of trade agreements. Despite these differences, there are some very large efforts going on right now to try to fit the digital trade internet governance issue into the trade policy shoebox. And I think these efforts are not terribly well understood, and I hope when we come away from the session later today, we'll all understand it a lot better. Let me give you a little background on some of the negotiations where this issue is being fought out. First is the Trans-Pacific Partnership, or TPP negotiations, which is often referred to as a mega regional trade deal, as opposed to the NAFTA with Canada and Mexico was a regional trade deal. It's a mega regional trade deal that involves the United States, Japan, and 10 other countries in the Asia-Pacific region. The biggest country not included in those talks is China, but there's hope that somewhere down the road China may want to dock on to the TPP agreement. The TPP includes an e-commerce chapter, which is focused on gaining agreement among these 12 countries for rules governing digital trade. The United States has said that it wants in that chapter, among other things, commitments that countries won't charge import duties on e-commerce products such as software or music, that countries will agree to uphold, quote, a single global internet, ensuring that cross-border data flows are not blocked, consistent with government interests in legitimate regulation of privacy concerns. And that there will not be what are often referred to as localization requirements, which force companies to set up infrastructure, data storage, and other things within countries rather than being able to operate freely across borders. I don't think WikiLeaks has got this chapter yet. I may be wrong. So it remains secret, and we don't know to what extent the United States is actually getting what it wants from the other countries involved. But those negotiations are entering their final stages right now. There's a big meeting of trade ministers that's taking place in Maui in Hawaii. I have no idea why they're doing it in Maui. How do you expect to get any work done in Maui? But anyway, in theory, they're going to try to wrap up this deal at the end of this month. So this is on a very fast track right now. The second set of trade negotiations, which WikiLeaks did get and release the chapter, is the Trade and International Services Agreement, or TISA negotiations. The TISA talks are what are referred to as a plurilateral negotiation. Sorry for the trade wonker. It's intended to distinguish it from the multilateral agreements that take place through the World Trade Organization. The TISA involves 23 countries that represent about 70% of the world's trade in services. And there is an annex on electronic commerce being negotiated. The bracketed text of that annex shows that there are some pretty substantial differences among the 23 countries on issues including privacy, online consumer protection, protection of personal information, the regulation of the electronic spam that we all hate. My Verizon is unusable for any Verizon people out there. Data localization and a host of other issues. So a lot of controversy there that you can see actually in the text, those secret texts that have now been made public. And then finally, the third set of negotiations is what's referred to as the Transatlantic Trade and Investment Partnership, the effort to negotiate a big free trade, though it's really more a kind of regulatory agreement between the United States and the European Union. U.S. and EU have a long history on negotiating these issues through the so-called safe harbor talks, which I think we'll hear more about, that have tried to balance European privacy concerns with U.S. commercial interests. The Edward Snowden revelations about U.S. spying activities have really thrown a wrench into that whole undertaking, raised very difficult issues, particularly about the relationship between national security and data security. So as I said, to help us think through these issues, we have a tremendous set of panelists. To my immediate right, Usman Ahmed, Head of Global Public Policy at PayPal and previously Policy Counsel at eBay. His work covers the whole gamut of relevant issues here, including trade policy, intellectual property policy, financial services. To his immediate right, Joe Alhadeff, Vice President for Global Public Policy and Chief Privacy Officer at Oracle, which, as you all know, is the world's top supplier of information management software. It's formerly with the U.S. Counsel for International Business, a great organization, does excellent work on a whole host of international trade issues, and manages Oracle's government affairs work now on this whole set of issues. To his immediate right, Burcu Kilic, did I get that right? Not bad, okay. Legal counsel at Public Citizen. Public Citizen, the Ralph Nader created consumer group, which has long been at the forefront of pushing for greater transparency and accountability in trade negotiations. She is an expert on the legal, economic, and political issues surrounding intellectual property and trade, and recently co-authored an excellent analysis of the WikiLeaks teaser chapter on e-commerce that I recommend to you. And finally, to the far right here, or your far left, as it were, for those of you watching on the live stream, Susan Aaronson, a longtime friend of mine and a trade co-conspirator, who's the research professor of international affairs here at George Washington University, and one of the country's leading experts on a host of trade and globalization issues. Her recent work is focused very much on internet governance and internet freedom and the issues raised by this new form of trade. So each of our panelists is going to make some brief opening remarks. I will ask them a few questions, and then we will open it up to the audience. We're also taking questions for those of you watching on the live stream. We're taking questions via Twitter. And so to ask a question on Twitter, use the hashtag IGF-USA_trade. Again, that's hashtag IGF-USA_trade. So Usman, I will turn it over to you, and thanks again for being here.
Great, thanks Edward. Thanks for the to Susan and to the organizers for inviting me to participate in this important, interesting, and I think very timely, given where the U.S. Congress is and where the trade agreements are right now, topic. And Edward, I thought it was a great kind of overview of where things are. And what Susan asked me to do was kind of provide a little bit of the business economic context for trade agreements. And so I was thinking, let's go take a big step back. Why did trade agreements even exist? And that's because all of a sudden in the, really the first big trade agreement was in the 1940s after World War II, where you started seeing all these globalized businesses that were kind of repairing a lot of the global economy. And there were all these rules about trading goods across borders that were divergent. And so, several countries came together and said, why don't we try to improve this system so it makes it easier for people to trade their goods across borders. And fast forward to today, where you've got the internet kind of completely changing who is actually capable of engaging in that type of trade. And so I'm going to throw a lot of statistics out in a little bit, but I thought it was most helpful to understand the economic opportunity through a case study approach. And so the particular case study I want to focus on is a really small business out of the state of Washington called Game Clip. Okay, and Game Clip was started 3 years ago by a student at the time at the University of Washington who was studying applied mathematics, but the product doesn't have anything to do with applied mathematics. He took a class on kind of engineering and design. His name is Ryan French. Took a class on engineering and design, and he saw that a lot of his friends were playing smartphone games in class. And actually, I think the Internet Society was giving a keynote here today, and they have a really interesting report out this couple weeks ago from their chief economist called the Global Information Society Report. And one of the key findings is about the mobile internet, and it finds that I think 32% of all internet traffic on mobile is actually smartphone games. So that's pretty significant marketplace. And so Ryan saw that this marketplace was growing. He saw his friends were playing kind of smartphone games. And he noticed that they weren't just playing like Candy Crush Saga or like something simple where you can just use your hands. They were playing like Halo and like super complicated games on their smartphones. And so he said, man, that seems really difficult to just use your fingers and play that. So he had taken this applied engineering design class, and he kind of designed this product called the Game Clip, which basically connects onto your smartphone. And at the bottom, you can connect a PlayStation controller, and you can play very complicated games now on your smartphone. So cool design, cool product, but now what? He started a website, www.gameclip.com, and all of a sudden, people from all around the world said, man, I really want one of those. And within the course of 1 year, he had sold a Game Clip to 80 different countries. So as a student in undergrad, starting a business, within a year, getting it off the ground, getting a website, and selling to 80 different countries. If this was 25 years ago before the commercial internet, not possible. And even if it was 5 or 10 years ago, before there was kind of ubiquitous connectivity and smartphone penetration, you would just not see this be possible. Ryan might have gone to like his local retailer and tried to get it in there, and then maybe he would have gotten it national, and then it would have taken 20 years to get international. But now he can just launch the website, and all of a sudden it's everywhere. So that's a case study, but now I think there's a lot of data to prove out what the benefits of this is. And I think probably the best work has been done by the U.S. International Trade Commission, and we have David Coffin here, who worked very closely on that report called the Digital Trade in the Global Economies Report, Part 2. And I think the key findings were the GDP increase from digital trade was found to be about between 517 and $710 billion to the US GDP. And interestingly, so there's a lot of talk about, I think there will be talk here and in other forums in technology about how this affects, how technology and globalization affects equality and jobs. And so the report has some very interesting findings on the fact that real wages actually go up by almost 5% as a result of the efficiency gains from technology and the internet. And then most interestingly on jobs, the report finds that there's a potential increase of 2.4 million full-time jobs in the United States as a result of digital trade. So a lot of very positive upward economic trends for the US economy as a result of this proliferation of digital trade. And as I mentioned, not just for really, really big businesses, but actually for really, really tiny businesses. And so the last thing I'll say before I turn it over is kind of we're going to be talking, I think, a lot about trade policy. And again, so trade policy has traditionally, as Edward mentioned, been focused on agriculture and manufacturing and big business issues. And I want to toss out two thoughts. One, there are certainly these new interesting issues that I think Joe and Burcu will focus a lot on: privacy, intellectual property, where there really needs to be a shift in the way of thinking about those issues in relation to technology. But I also want to throw out the idea that manufacturers and agriculture businesses also care a lot about technology and how trade agreements are playing out. So for example, Boeing sends updates to its engines all around the world using the internet. And I think many of us, or hopefully none of us, were caught in United's recent kind of server glitch where all their planes were grounded because of a technology glitch. So you've got aviation issues, you've got manufacturing issues. Cargill, which is kind of like a food production company, they do data science on how to develop more efficient food production. So you've got agricultural issues that are internet issues. And so really it's almost, we have all these trade agreements you talked about. They all have chapters and segmented approaches to the way they approach policy, but now the internet is really cross-cutting everything. And so thinking about the democratization of all of these industries and how the internet affects that and how we can promote that, I think is kind of a very, very important topic that I hope we talk a little bit about. Thanks.
Excellent. Thanks very much, Usman. Joe.
Thank you, and thank you for the opportunity to join in. So I'm going to build on what Usman had said in talking about some of the benefits, but I'm going to talk about perhaps the technology context a little more directly. And a lot of people say data is the currency or the oil of the new economy. But what does that actually mean? Well, if we think about today's world and more the world that's coming towards us tomorrow, people interact with people interact with objects, objects interact with objects in computer-aware environments to avail themselves from services delivered through the cloud, supported by a level of analytics we haven't understood yet and haven't used until today. That is the world we live in, for which data is an essential element, for which data doesn't understand what a geographic boundary is, and for which most business uses don't limit themselves to within a geographic boundary. His friend with GameClip had a physical product, but he actually it was advertised and through word of mouth on the internet. It was because of internet-enabled games where people were playing Halo with each other in spare time across jurisdictions. So this is the new world we live in. The buzzword that gets used, especially when you talk about trade policy or if you're talking to anyone from the OECD, is data-driven innovation. And I will say that data-driven innovation is a potential engine of incredible economic growth and societal benefit. I say potential because there are ways we can screw it up. And part of the question is, what is the relationship between trade policy and data-driven innovation? In APEC, there had been a document which was called the Digital Prosperity Checklist, and we can get into it in the Q&A, but...
Joe, just quick, can you tell, I mean, it's
Sure.
sort of different levels of expertise here, so tell
Sure.
everybody briefly what APEC is.
APEC is the Asia-Pacific Economic Cooperation. So if you think about it, think of countries that have a Pacific Rim, including the countries you don't think of that have a Pacific Rim, like Russia, Canada, et cetera. So it's not just the natural Asia-Pacific countries you think of, but also economies in Latin America that face the Pacific, et cetera. So this concept of the Digital Prosperity Checklist came up with the idea of the 6 I's, alliteration cells in APEC. And the 6 I's are important because they were infrastructure, investment, information flows, innovation, intellectual capital, and the last I was a cheat because it's integration only because we couldn't think of a good I for trade. But if you think of trade policy is actually dependent on the other 5 I's. It's a matrix. So if you get information flows wrong, good trade policy isn't going to help you because that's integral to it. If you don't have investment, you're hobbling the others. So think of these as mutually dependent and matrixed concepts. So now you have economies who all want to participate in this thing, the digital economy. They want to kind of be the next whatever in the digital economy. So what we start seeing is countries try to think of, how do I drive business to my country? And in some cases, you still have people looking at a constructive concept of, how do I do the race to the top? How do I make myself the most desirable location for business to want to be? And you see some countries that are doing good things to actually attract business, whether it's because they've laid out the right infrastructure, they have the right policies, et cetera. But then you see some people who are looking at data localization as a forcing function. So I'm going to create a set of requirements that make you come to my country. But data localization is many things. It's not just one thing. So one of them in the forcing function is related to indigenous innovation and industrial policy. In that one, you have countries that may be saying, you have to manufacture in my country, your data can't leave my country. And the reason you want to do that is because you want them to build the hub in your country, or you want them to actually do something or contribute to the industrial policy of your country. And that can be done in a very coercive manner, or it can be done in a light touch manner. The light touch manner, it operates as a tax on your doing business. The coercive manner, it operates as a significant constraint on your doing business. The problem is that it's a fallacy to think that a forcing function can bring you economic prosperity. There have been lots of studies that just demonstrate that that just doesn't happen. There's also a confusion as to the leverage. So I'm going to take cloud computing as an example. And we are also a cloud company, so we know of this thing. And there's this concept that my country has to have a cloud operator. Well, actually, your greatest leverage is not in serving the cloud, it is in using the cloud. So if your country has access to the cloud, that is the biggest thing that is going to help you economically. Over time, there's no reason why you shouldn't consider being a cloud operator or anything else, but it's not the first stop on the highway. The first stop on the highway is letting the small businesses and other businesses and government in your country benefit from the use of these technologies. So that's one thing. You then have data localization as a non-tariff trade barrier to either protect local industry, protect incumbents, or transfer technology. this ends up being a race to mediocrity in a captive domestic market. There's lack of global competition, which leads to lack of a cutting-edge technology in the marketplace. Furthermore, the fear of exposure to the loss of intellectual property may lead to exclusion of technology from the market. So in many ways, these kind of elements hobble the market for quite a long time. The last data localization is actually the hardest to judge, because that's the data localization to protect citizen rights or national security. And the reason why that's the hardest to judge is those are significant and legitimate exercises of government power. The question is, what is the motivation? Because you can use those terms not to affect those ends. You can use those terms to affect one of the two previous localization methodologies, but you understand from a PR campaign that if you say what you mean in both of those other two, it's negative press. Whereas this other moniker may actually be beneficial for you. So this is a very difficult thing because understanding motivation is difficult because most regulatory and other edicts don't come with a truth in advertising this is our motivation for why we're doing this. It's probably better that they don't actually. And a potential workaround to the thinking on those is the idea that within the GATS already there is language related to security and privacy as an exception. And the GATS has limitation language related to that, including the need to have the concept of
I'm going to do one more acronym on you. So GATS is the overall umbrella for trade in services as part of the WTO. The specific negotiation I talked about, TISA, is a much more focused negotiation with a smaller group of companies. GATS are the sort of very loose rules that at the moment govern everybody. Sorry.
And in the trade world, GATS is kind of the equivalent to the sign at Disney that you have to be this tall to get on the ride. So if you're going to learn any acronym in the trade world, that's the one you need to know. And the other concept is, apart from just necessary, is it the least intrusive means where multiple means are available? Because usually there's not just one way to regulate or think about something, whether it's privacy, security, or whatever. Is it the least intrusive means to accomplish your necessary end? And then finally, have you narrowly tailored and limited your drafting to the narrow scope of the objective you're trying to achieve? So that's actually one of the ways of thinking about it. And then lastly, I'm going to use the jet engine concept because often it's actually other people sending information. Boeing may not be making those jet engines, but because a good friend of mine at GE does, and so he would want me to correct that. And so, but the concept is the GE engine sends about 1 terabyte worth of data during a long flight on its maintenance and performance so they know what to do with it when it lands. And the answer is not a single piece of that data is personally identifiable, though all of it is tremendously important and that communication needs to be secured. So the concept is when we think about data flows, we have to think about what is PII, personally identifiable information, what is not. We also have to think about, in our innovative use of technology with these new analytics, which elements of data are important to us? Because while we may want to make sure that our privacy rights are secured, how we secure them may need to have more flexibility so that we can make use of these innovative technologies. But I'll leave that as part of the Q&A.
Excellent. Thanks very much, Joe. Burcu.
Okay. Thank you very much. So, as someone who has worked at the intersection of intellectual property and international trade for a decade, I can speak with confidence that international trade agreements they became a vehicle for norm setting on internet policy issues, from intellectual property to e-commerce, from cross-border data transfers to privacy, local technology, and investor-state dispute settlement mechanisms. Recent mega multilateral negotiations, like Edward mentioned, TPP, Trans-Pacific Partnership, TTIP, Transatlantic Trade and Investment Partnership, and last but not least, Trade in Services Agreement, TISA. They devise a trade model and incorporate internet governance issues into the trade negotiations. So these negotiations are closed, and that's why they are a poor forum for making internet policy, and that leads to a policy that naturally favors businesses, with major lobbying operations in Washington D.C., Brussels, and Geneva. And they are not kind of like a forum that we like the issues to be discussed. Joseph mentioned privacy. Yeah. So like one of the biggest issues in all these free trade agreements is the cross-border data transfers, and the TPP will be the first free trade agreement which will include a direct obligation for the cross-border data transfers. E-commerce chapter hasn't been leaked, so we don't know what is it. We don't know the provision, but we can guess because we know that USTR uses like the previous FTAs as a template. So the chorus provision, and we are guessing that it's based on the chorus.
Again, Burcu, so chorus is that. Sorry, this is hard because it's what's interesting, and challenging about this is because we're bringing two worlds together. Right, you folks all know a lot more about internet governance than I do, but trade chorus is the U.S.-Korea Free Trade Agreement, which was concluded in the Bush administration, ratified under the Obama administration. And many of the provisions in the Trans-Pacific Partnership are very closely going to mirror the provisions in the U.S.-Korea trade deal.
Yeah,
sorry, go ahead, Burcu.
But there wasn't a direct obligation for cross-border data transfers in chorus, but there would be one in the TPP. So we don't know the provision. But when you talk to the negotiators, they try to clarify that don't worry, there is an exception there for privacy, and we don't know. We haven't seen the privacy exception. And interestingly, Joe mentioned that talk about the OECD, and OECD says that the data talks about the data-driven innovation. But the OECD report, the OECD Digital Economy Outlook report, which came out like very recently, also to talk about privacy, and it says that no country has a national strategy on online privacy protection or funding to do research for this. And privacy viewed as a matter for law enforcement authorities. So in trade agreements, there is cross-border data transfers. There is a direct obligation for that, but we don't know whether there is an exception for privacy. And when you talk to the negotiators or the businesses or like the rule makers, they say that don't worry, there's GATS 14 exception, which is a general exception, which was negotiated before pre-internet era, and which was like I think that's concluded in 1995, and which has never been tested, which has never been subject to WTO WTO case dispute resolution. So we don't know whether it will work or not, because it's structured in a way that the countries, if they come up with measures, it should be like necessary, and then you have to prove that your measure shouldn't amount to arbitrary and it shouldn't create an unjustifiable discrimination. All these trade terms we don't know much about, and it shouldn't place a disguised restriction on trade in services. It's like a completely foreign language for us. Like I've been dealing with trade more than 10 years, but I've been focusing on intellectual property and trade. And when I read the GATS 14 exception, I'm like, okay. So no one knows whether it will work. And the TISA leak came out like a couple of weeks ago, and I had the privilege to analyze the text. And it's same in TISA. We know that there's a direct obligation for cross-border data transfers, and there is a ban on local servers, but no one talks about privacy. And when you talk to the TISA negotiators, they are like, don't worry, there would be a general exception in core tax for privacy. But our position is like, okay, we are talking about internet. We are talking about internet policy. What happened to multi-stakeholderism? You know, we want the data flows, and it is needed for 21st century economy. But we also need to talk about privacy. And the issue is like you can't really discuss or negotiate open internet behind closed doors, and we should be part of this discussion. If there would be an exception for privacy in these trade agreements, it should be discussed. You know, we can't really rely on general exceptions which were like negotiated during the 1995, like during the 1990s, and it has which haven't ever tested, or which haven't which haven't been like subject to a dispute resolution. So that's our standpoint with this trade agreement. There are other issues like fair use, like for instance, and with Usman, we fought really hard for a fair use exception in the TPP. The USTR came up with some kind of solution, which we don't think that
Sorry,
it's
can you
enough.
explain that just a little more? So what is a fair use exception? Just briefly?
I mean, most of the U.S. internet-related U.S. businesses and services have been developed because of the fair use exception, because it's a limitation, an exception for the copyright. So in international law, we have limitations and exceptions for copyright. But U.S. has its own structure, which we call fair use, and which has been used by all these internet-related services and goods. But the problem is like USTR, instead of like promoting fair use, pushing for fair use in free trade agreements, they push for this they push for three-step tests, which comes from the international agreements. And for in the TPP, we fought really hard for a fair use language, you know, and USTR came up with like a solution, a kind of solution, which didn't satisfy us, and I don't think whether it satisfied the US businesses either. But it's another thing, because when we talk about the internet, it's about users. It's not about like, it's not only about the content industry or the ICT technology, or it's also about the users, and unfortunately we don't really have like, you know, access to the text, and no one listens to us.
WikiLeaks needs to get it out there. They just got to work harder.
Yeah, we are looking for the e-commerce sector.
Thank you very much, Burcu. Susan.
Okay, so I'm going to take a very different perspective on this, and what I'd like to do is just get you to think about whether or not, I basically think this could be a great thing to promote the free flow of information through binding obligations in a trade agreement. Could be. The problem is it's a very incomplete analysis, and part of the problem, I think, as I've been trying to put forward for the last, I think, 3 years with Rob Maxim, who now works with Ted at the Council on Foreign Relations, is that basically, when you're regulating information flows through language in a trade agreement, you're really doing internet governance, but you're not saying you're doing internet governance. But it's not just internet governance that you're doing. You're affecting democracy, right? Because so much of governance occurs online now. You're affecting access to education and healthcare, and scientific and technological progress. So I think we need to think long and hard about whether or not trade agreements are the best place to do this. Again, I want to look you in the eye and say, I really want to do this, I just want to do it right. Okay, so what does doing it right mean? It seems to me it has to begin by thinking about what are the implications of encouraging the free flow of information, and then providing exceptions in a trade agreement to limit that flow, right? So an exception basically says, here are your obligations, and here are when you can breach your obligations, as long as you do so in a manner that is necessary, proportionate, and non-trade distorting. Okay. The problem is that the United States hasn't really thought well about this, and part of it is because in the U.S. government there isn't one person responsible for the internet, and also because the people at USTR, there's no mechanism for them to really talk about what does it mean to encourage the free flow of information and its relationship to these other issues I mentioned before, such as digital rights and scientific and technological processes and governance, etc. So I think through Edward Snowden, if you believe what he said is what he revealed is correct, netizens have learned about the inconsistencies in U.S. and other governments' attitudes towards the internet. So here the United States is saying, we absolutely want to make the free flow of information a default, but yet we've usurped that flow by surveilling the world's communication. We've shown utter disregard for other countries' norms and rules on privacy. And we often signal to other governments that if you don't adopt our norms on site takedowns, okay, we're not gonna do a trade agreement with you. And while I agree that we have to find ways to protect online copyright, we also have to find ways to be respectful of other nations' approaches to those norms, as well as the type of law they had. As Burcu said, other countries have civil law, they don't have fair use. Okay. Using exceptions, that really worries me for information flows. And the reason I think that is because exceptions are very broad and they're very rare. So for example, since the GATT, the precursor to the WTO, it began in 1948, excuse that passive voice sentence. So we've been conducting freer trade with many nations since 1948. No nation has ever used the national security exception. As Burcu said, there's never been a trade dispute related to privacy. So we don't know how these disputes could play out and if they will be protective of these national norms or rules that require nations or that lead nations to breach their obligations. So all I'm saying here is that do we really think that saying here's the default free flow of information and then saying the way to deal with this is through exceptions if you want to breach the rules for national security reasons or for privacy or for public morals. That's the way it's always been done in trade, and I'm cool with that. But what I'm not so sure about is does that work with information flows, because as Ted pointed out to you, and as you know well, information flows may or may not be traded because no money exchanges hands when you and I review an article about whether or not Madonna is a mediocre singer or something like that. Okay, now I don't want to diss the United States only because other nations or groupings of nations are equally inconsistent. And what I mean by that, for example, the EU says, hey, in TTIP, no data protection. We're not going to discuss it. Wait a minute, guys. But there's the exception for privacy. So there's something in there, and it certainly relates to the EU data protection rules. There's got to be some sort of reconciliation of that. Okay? The United States, by the way, in TPP has already accommodated Australia's demands. Australia has said, hey, we want to protect the healthcare data of our citizens. We have a law on that. So we are not going to let our healthcare data of our citizens be on non-Australian servers. So given that the United States has accommodated one nation's approach to privacy, I think in the future we're going to have to find something new and creative that works. And maybe an exception is not the best way to go with that. I just want to raise that in your mind. The next thing is that clearly the revelations about Snowden have led other countries to distrust the United States and distrust companies that provide cloud services. I think that's incredibly unfortunate. And there is no doubt in my mind, although I've never seen any good measures of this, that has inspired nations to adopt measures that they say are necessary to preserve trust and protect their citizens' data or consumer data. But they say they're necessary and we say they're protectionist. But we don't really know. And who's to judge that? Usually that's done in a trade dispute. I really wonder whether trade professionals can make that distinction. What's necessary, right, for public morals, to protect privacy or for national security versus what is protectionist. I just don't think that's an easy decision for people on a trade dispute panel to make. So I'm just wondering, again, if that is going to work. And then we also need to say, right now, no trade agreement that discusses e-commerce says much about issues like internet stability, okay, which I take to mean, which some people call internet resilience and other people call cybersecurity. Okay, but there's nothing in there about, for example, things that, if information flows are traded, guys, malicious information flows are also traded. And you know malicious information flows as malware. So should trade agreements govern that? Well, wait a minute, you can't have it both ways. If you're going to govern information flows, you got to govern malicious information flows. Frankly, I really don't want to see the WTO in the issue of cybersecurity, but I could be wrong here. But again, I'm saying to you, here we are moving ahead, but we haven't really thought about the consequences of this. Now I want to talk about another issue which relates to human rights. In the United States, we have a very different definition of human rights than other countries. And the reason is because in the United States, we have political and civil rights, but we really don't have economic, cultural, and social rights. And we need to, American policymakers and citizens need to think about the notion that other nations provide public goods online, like education. We do too, but the government doesn't really do it, right? Private companies do it. We need, and state universities, obviously, and private universities, but we need to really think about why governments have taken the positions they have as to the appropriate role of governments online and what governments should be doing to regulate the free flow of information. So that's a question we need to think about. We also need to think about, in the United States, we don't really think about people using the internet to organize as a basic right. But other governments restrict that online. So they're restricting access to information. They're restricting human rights. Are trade agreements really going to govern that? Is that really what we want to see? I don't know. It could be a good thing. Because I'm in the school, you may have heard a while back, Google wanted the US government to challenge Chinese censorship as trade distorting. Okay? And at first, I thought that was a great idea, because if you believe that information flows are traded services, you should be able to challenge restrictions on governments, when governments restrict such services across borders, right? So therefore, the trade regime could be a venue to enhance some human rights. But the more I think about this, is that really what we want? So my goal here, to summarize, has been to just get you thinking about this. I've tried to talk about this with the USTR. I know on a daily basis, USTR speaks to people at the Department of State whose job it is to encourage scientific progress, or people whose job it is to encourage digital rights. And yet, I don't feel convinced that they've really weighed the implications of this. And why I am the queen of ambivalence, because I'd really like to see it happen, but then I worry, be careful what you wish for. So I have some recommendations for policymakers, and I put it in a 2-page policy brief that's a handout back there, but basically, the first thing I'd like to see is, hey, policymakers should be thinking about this from the internet as a whole. There should be 3 people in the US government who say, hey, wait a minute, is this really gonna be good for the internet or not? Second thing I'd like to see is we need to be thinking about whether or not, if we do this, it's going to be good for interoperability and the rule of law. And the reason I say that is because I'm on something called Working Group 2 of the Freedom Online Coalition, which is 24 governments that are trying to get together to define shared norms for the internet. And guess what? I don't see these shared norms. Very different norms for privacy, very different norms for what the rule of law actually means, because they have different concepts of the role of government online and what the internet should be doing. And then finally, what is a barrier to digital trade? I don't see why the WTO Secretariat, if TISA is going to move forward, the WTO Secretariat does scholarly reports all the time for members. Why not define what exactly is a barrier to digital trade? Okay, to me, server location seems like such a barrier, if you're going to require that, but when is it okay, in the interest of protecting your citizens' privacy, to require that the server be there? This is going to be really hard to define. And I just learned that the World Bank is going to try to look at that. That's a great thing, because we're moving into this without really knowing what we're doing. And is that a good idea? Big question mark. I'll leave you with that.
Excellent. Thank you very much, Susan. Thanks to all our panelists for a fabulous introduction to this. I'm going to ask a couple of questions of the panelists, and they may want to respond to things that were said by others here, but then I'm going to turn it to the audience pretty quickly and take your questions, because I'm sure there's a lot out there. A reminder for those who want to send in questions via Twitter, use hashtag IGF-USA _trade. Usman, I actually want to throw a question directly at you. I know what our other panelists are worried about. Susan's worried about whether trade agreements are the right form here and how to create the best construction for ensuring a robust internet, but also dealing with privacy concerns. Burcu is very worried about the way it's being negotiated. These trade agreements do take place, and this is a long tradition. There's secret negotiations. The idea is, you don't want to reveal your positions publicly because it will be hard to back down from them. And so Burcu is very worried about is this an appropriate issue for that sort of form. Joe is very worried about governments using coercive measures like localization to try to force businesses to operate in ways that may not make a lot of sense for them. What are you worried about?
I would say I'm worried about what's actually in the substance of the trade agreement, probably more than anything, because one thing that I don't think people outside trade policy world would know, but everybody inside trade policy world knows, as you mentioned, or as Burcu mentioned, the TPP will be based upon what was in the Korea Free Trade Agreement, which was based upon what was in the last, so it's kind of very sedimentary. And the internet is not sedimentary, right? The internet disrupts everything. So the idea of kind of revisiting all of these provisions, whether they're, and as I keep mentioning, whether they're in financial services area, whether they're in the goods area, whether they're in the agricultural area, I think that's what I'm really concerned about is, are those individual segments being thought about? As Burcu mentioned, there have been limitations and exceptions in the international trade space for intellectual property, but do they make sense when, everybody's referencing everything online and copyright really needs to be rethought? Trademark, for example, potentially needs to be rethought in the globalized internet world. And then one little thought I'll throw out there, because I don't know when I'm going to get to talk again, is this idea of exceptions. And I just wanted to weigh in really quickly, just to throw out to the audience the idea that there has been actually a dispute resolution case related to the internet, and it dealt directly with an exception to cross-border services. And it was a case actually involving the United States, where the United States had 4 laws that prohibited gambling online. And actually, the United States was challenged by the tiny little government of Antigua, saying you shouldn't have these laws that prohibit online gambling. And the U.S. said, well, this is a public morals issue. These are our domestic regulations designed to protect our public moral of prohibiting gambling. And the interesting part I think we really need to think about when we're thinking about exceptions and how they're applied and how trade policy works is actually 3 of those laws were upheld. And that it is okay to have a public moral for gambling, whether or not you think that's okay or not. But the only one that was struck down was only struck down because the actual law said domestic gambling providers are okay, but international gambling providers, you can't provide your gambling service into our country. That's what trade policy really deals with, is discrimination. And so when there's a law that treats a domestic service provider a lot more favorably than an international provider, that's where we might have a trade policy issue. So just last thing I'll say is, for Joe's example of these server location issues, if you're a domestic business in Germany, you probably have a server in that country anyway. And so by creating a law that requires everybody to have servers, you're treating foreign providers differently. So that's the mentality to think about trade, and why it's, I think, potentially very interesting from an internet perspective, where the internet is already so global and doesn't treat bytes and bits differently, to have a trade regime where everything is, again, thought about very globally and doesn't discriminate.
It's interesting, just, in this exercise, we're all kind of filling in background from the different parts that we know. There's been a lot of reference to disputes here. And just to be clear, one of the reasons I think that so many, for want of a better word, sectors of our economy want to be part of these trade agreements is because it has dispute resolution mechanisms. I mean, the pharmaceutical companies wanted to see patent rights included in the trade regime because there was some way to enforce those internationally. The WTO, if you're believed to violate WTO rules, the WTO will assemble what's in effect a court. It's arbitrators who are experts in trade law who will sit and rule on whether your behaviors violate the rules that you agreed to in the WTO, and if the answer is yes, potentially your country is subject to trade sanctions. I think it's fair to say there's no other international organization that has that same sort of dispute resolution mechanism that has a real bite. And so, when our panelists are talking about, has this been dealt with through the legal process, that's what they're referring to here. is this essentially international court arrangement that the WTO has set up, and that a lot of interested parties want to be able to avail themselves of, because it's a powerful. Did you have a question specifically on this, or?
Specifically on that.
Yeah, please identify yourself. Yeah, thank you.
I'm Patrice.
Yeah.
I don't think this is working.
Is that well? Just speak loudly then.
Okay. My name is Patrice Lyons. I'm an attorney in D.C., and I've been involved in the internet back since the 70s and the basic technology. Bob Conant and Surf, I represented them for a number of years. So right now we're moving from location-specific identification to actually identifying for this, the data structures, independent of location. It's backwards compatible with the other. Now, I think Ms. Aaronson was noting about the information. Now, the internet, as I'm viewing it, is essentially an information system of global stature. And as we're moving away from the location-specific to managing information itself, I'm really concerned, and I'm familiar with the internet case that I know John Jackson over Georgetown, he was really interested in that, is that you're actually then setting up, and the dispute resolution is exactly what I'm concerned about. That's why I raised my hand. Because if you're going to set up a body that's sort of supernatural, national, to actually govern information flows, then that gives me pause, because what happens with our basic fundamental constitutional rights in this process?
Can I
The right to
take that
free
one?
speech. And so essentially, it's that very situation where you have a trade court that may not be responsible to actual local situations. So is there any possibility of going to the trade court and getting out and going back into the national laws?
Good question. So to what extent do we want to turn over some of these issues, which are key to a whole bunch of sectors of our economy, to the possibility of international court arbitration? Susan, you wanted to respond to that?
I
and
think
maybe
there's a little bit of a misunderstanding here.
pull the microphone
Okay.
closer here too.
So the first thing is, this is all a big if, right? Because we don't know if TISA will, if the negotiating states will come to TISA, and then it will end up with the trade dispute mechanism, and it'll be part of the WTO, or any other trade dispute mechanism that is part of any other trade agreement, right? None of these are completed agreements. But please understand this. In any trade dispute, the first thing that happens is negotiations among the two parties. And if they can't find common ground, then they select the panelists, okay, for that trade dispute. And let's say it's the United States versus Antigua, as in the public morals case. Okay, then what happens? This is a very democratic rule of law procedure. And in fact, it's very transparent, although it takes a really long time. But U.S. sovereignty is in no way affected by this, and let me explain why. Because first, when the panel dispute is issued, okay, the United States can do one of three things, or any other country. They can ignore it and potentially have retaliation. They can change their policy, or they can compensate and keep their policy. So U.S. sovereignty and democracy is in no way, shape, or form affected by it. But then there's an appeal,
Yeah.
if you want. But the appeal is totally binding. But again, the United States can ignore what the panel says, but then risk retaliation. And I can tell you, in the 60-ish years since the GATT, no major big country has ever been retaliated against. It's small countries that are retaliated against.
But the problem I see
Yeah.
is not necessarily that it's not going to go through this. And I'm familiar. I went back to the NAFTA days, and I remember because they incorporated some broadcast satellite work that I was involved in at the time. And essentially, though, you still have the notion of a group of trade specialists making an initial cut on very sensitive freedom of expression issues. And I think that there has to be some escape valve here, because otherwise we're going down a road, especially with the internet expanding, more specifically into managing units of information. We call them digital objects or digital entities. And so you're actually then at a very granular level managing information. And it's not just the bits and bytes here.
Well, I'd be interested in other responses on the panel. I mean, the idea of an escape valve is a very interesting one. And in some ways, it's similar to an exception. I mean, when we look at issues like privacy, say, is everybody on this panel comfortable with giving the Australians an exception for health records? Or the Canadians have talked about, a broader range of personal information. I mean, could we all agree on this panel on what a sort of reasonable set of exceptions or escape valves might be? And I open that to anyone who wants to take it here.
I'll take it.
Thanks, John.
I think, first off, I'll disagree with something Susan said in the sense of there's no commonality of privacy norms. There's no commonality of the role government should play in privacy, but that's different than privacy norms. If you look at fair information practice principles in the United States, if you look at the OECD guidelines, if you look at the Council of Europe Treaty 108, if you look at the APEC framework, if you look at the EU directive and the draft regulation currently under consideration, they all share core principles. The core principles are not at issue. In fact, the OECD, when it revised its guidelines drafted in 1980, the core principles were seen as continually applicable. How you applied them is what changed. So I think, the age of the document is not the question. The norms are not the question. I think when you look at the privacy exception and the security exception, I don't know as much about the public morals exception, they have cast a huge shadow because countries have not been willing to run up against the exception to have it applied because every country wants to maintain the exception if they need it. We were having this issue on the security exception on the preferential market access with India when it was dealing with private sector. And every government, whether it was the Indian government or the US government or Europeans and Japanese who were all involved in the mix, the concept of coming up to that exception was done on tiptoes and very tenderly because no one wanted to trip the exception. So the exceptions have cast a shadow. I also think that when we look at the exceptions, while they themselves haven't been applied, some of the wording in them has actually been dealt with in other trade contexts. So the words necessary and arbitrary are not without meaning in the trade world. They actually have a long history of meaning in the trade world. So we're not at this kind of zone of, green fields, we don't understand anything about these topics. I think the idea of the concern that was raised of we're atomizing data into these smaller components or objects and those data are working independently, it's an absolute truth in terms of where we're going. But I'm not sure that's what trade agreements are actually. I don't think trade agreements are in the business of trying to manage those, except where a law may distort the ability to use them. Because in many cases, localization laws are distortive of trade flows that otherwise exist. And if we can make sure that trade law goes in that direction only and doesn't become the micromanager of first choice, I think that's very important. So again, Usman actually said it best. It's your concern also. We don't know what the text says. There's a concept of we all know what we'd like to see. We're not sure what we're going to see, and so we're all kind of waiting with bated breath. Having a lobbyist doesn't give you access to that anyway. So, I think we're all in that same place. So I think we have to make sure that we are focusing where we need to focus and not letting us get out of control on the concept. Because, for instance, data flows is a governance issue. There are two types of governance, and I don't need to explain this to an IGF crowd, but governance of the internet and governance on the internet are very different things, and unfortunately, they're often confused. So again, these are the kinds of things we need to manage. And the last thing I would add is and Usman alluded to this, I think one of the things we have a danger of is what is commercial versus what is not commercial is now no longer a distinct line. And there is a danger for applying statutes meant to apply to companies to individuals who happen to be acting in a way that might seem a bit like a company. And I'm not sure people who are drafting these agreements are as sensitive as they should be to that distinction. I think they understand it, but they may not understand the ramifications of technology related to it. And we see this in the drafting of privacy law, we see this in the drafting of security principles, we see this in almost every element where it's now very difficult to distinguish between the individual and the company in some realms of endeavor. And in some realms of endeavor, the individual should be held to the responsibility of a company because they're engaging in something that could put others' information or data at risk. And this is a conversation we have not had in any depth and do not understand sufficiently. And it's one where we could have significant negative repercussions, both in the people who are trusting in those individuals to do the right thing, and in the individuals who are engaging in exercises of freedom that should not be otherwise constrained. So I would say that's also a topic that we haven't figured out how to deal with, and I don't think trade agreements are the place to resolve that topic, but I also don't know what the proper place is.
Could you just give an example of that? That would be really helpful.
Sure, you can have an individual who is developing a sharing website, and that sharing website is helping exchange information, and there's no profit, but the person actually happens to be getting notoriety, and that notoriety allows them to become more useful, and ads all of a sudden want to be on that person's event. So they've gone from what was an individual exercise to a commercial exercise. If that sharing of information happened to be services targeted at people whose families have certain types of illnesses, now all of a sudden you have massively personal and sensitive information. And if that person doesn't live up to certain security parameters and certain responsibilities, then they have played fast and loose with people's information. So it's this whole, where do you draw the line, especially in the new app economy that we have, is extremely difficult.
Very interesting. We have another question here.
Hi, my name is Susan Chalmers. I had a question about what happens when these two spheres are converging, so of trade and of internet governance. Usman made a point about substance in the text of the TPP. I really appreciated your comment that the TPP is in some ways sedentary because it's just built upon previous FTAs, and that doesn't necessarily take into account the new sections or the internet-related sections. Burcu made a comment about procedure in terms of multi-stakeholderism and transparency. We have that in internet governance land, but in the world of trade is quite different. So if you're a TPP negotiation round, is quite different than like an ICANN or a GAC session. Yet the TPP has provisions that relate to CCTLDs and how they handle disputes. So I'm just wondering how I know that we're kind of all working our way through it, but I'm wondering how you see this intersection playing out, and are there any possible ways that you can make these two spheres a bit more complementary?
Burcu, do you want to take a stab at that?
Yeah, sure. Okay, this is a tough question coming from Susan Chalmers. So, I dedicated the last 5 years of my life to the TPP, and I've been to almost all the TPP rounds, and I talked to...
Sadly, you're going to Hawaii at the end of the
month. Yeah, sadly, I'm going to Hawaii. And I talked to the negotiators, and my background is like patents and access to medicine, so I'm an access to medicines person, and it's a reality. Free trade agreements are a reality, because we learned by experience that, after WTO and the TRIPS agreement, the bilateral and multilateral trade agreements became the venue for international intellectual property rule setting. And it's preferable for the industry because it's behind closed doors and we have no input. So we learn by experience, and we try to be part of these negotiations. That's why I go to every negotiation round and I talk to the negotiators. I analyze the text, because when we talk about the text, it's very technical, and there are many people who can read the text and who can analyze the text. So that's what we are trying to do. We analyze the text, and luckily we have WikiLeaks and we have the leaks, so that we can see the text and we can analyze it and we can tell people what is inside the text. But with the internet, and especially internet governance community, that's something I observed in the last couple of years. Every time I go to internet governance events, I raise the trade agreements, and I'm like, guys, you really need to pay attention to free trade agreements. But internet governance community, for some reason, they ignore the free trade agreements. Like, and it has been quite disappointing for me, because we have this community and we have like the core values like multi-stakeholderism, and then you come to, and then there are free trade agreements, which happens between like the countries and with some lucky lobbyists who have access to the tax. And there is no role for academics or for civil society. But they set the rules. They set the domestic rules. And this is the reality in TPP, in TISA, in TTIP. And we don't know what is inside, and that's our biggest concern. So it's really hard to see whether this system will work. I think I always say, like, the free trade agreements was so 20th century, and now we are in the 21st century, and they promote TPP as a 21st century agreement, setting rules for 21st century. But TPP is a 20th century free trade agreement, which tries to set rules for 21st century, but it fails because it doesn't include like the stakeholders, main stakeholders, and it happens behind the closed doors. And we all witnessed during the TPA discussions, it's not working. And they will, either we like it or not, they will sign the TPP. But I have strong doubts that whether it will pass the Congress, because there are very, very serious concerns, and transparency is one of it.
I think Usman's metaphor is still one of the best I've heard. They're sedimentary, that each of these agreements is kind of laid over the history of the previous one. Susan, you had a brief comment, and then I had some questions that came in via Twitter that I wanted to get to the group, and then I'll get to you, sir.
I totally agree that there's this catch-22. On one hand, they're trying to negotiate a 21st century agreement to reflect 21st century economic change, and yet it is being done as if it's in the 17th century. I have tried to be a bridge person on that, because I wrote my dissertation on how policymakers talked about trade and what the public heard starting in the 1940s. And but here's the thing, I'll be Pollyanna, and I will say to you, it's naive to think that governments are going to change how they behave drastically in a negotiation, because this is just how it's done. It's secret. That said, we've seen the EU set an example. They have become much more transparent. I have been pressing, and many other people have been pressing USTR and the White House. It's really the White House that refuses to do anything differently. For example, crowdsourcing. Agreements, parts of an agreement. Let's say you want to do something different on copyright. Crowdsource it. See if there are ways to have online copyright. See if there are ways that people outside of the negotiators can think of a new approach. Because the only people who are going to participate in that crowdsourcing are people who have a stake in it, and they probably have some good ideas, and why not hear from them? But USTR is not going to change that. That said, in my lifetime, I have seen it change to some extent. The very fact that there are stakeholder meetings at the negotiation is a step forward. The problem is there's 97 steps back at the same time related to what's actually in the agreement. Sorry to hog that.
Good. I have a couple of questions that have come in over Twitter. Now I don't know whether they came from people watching here in the United States, in which case it was not trade, or people overseas, in which case these questions may well be trade, and they fall within our just a general question. What exactly is a barrier to digital trade? Maybe I'll throw that to you, Joe. I mean, you've mentioned localization, so that's saying companies, you have to manage your data in certain ways. But what are some good examples of barriers to digital trade? What does that mean?
Well, as I pointed out, you can have localization so that it requires you to have some infrastructure in a country, but doesn't require you to change your information architecture.
Okay. That would be a bit of a barrier, but
that's
not much
a
more.
hurdle, but
Right.
it's not a barrier. So
Got it.
I call that a tax on doing business.
Okay.
There is you can only have this information in this country on servers in this country, and you have to use this equipment. That becomes a barrier to trade, because that is essentially dictating to you your architecture. It's one thing to say, I want a piece of the pie, and I require you to have this, and actually often the requirement of a local server that doesn't require the information to stay in country is actually a requirement dealt with by local intelligence agencies. who want access to those servers. So there's a panoply of reasons on those things. But I think barriers are when they prevent you from trading. Limited barriers are also barriers, but they kind of exist all over the world, and people deal with them. They're not pleasant. They're not attractive. They're not what brings you to a country, and they may well keep you out of the country. But that is becoming a business decision, not an impossibility.
Did you want to?
Yeah, I was just gonna just keep echoing my sentiment, which is digital trade barriers are not just kind of censorship or localization, but they can be all over the place. So the USITC, again, excellent report, kind of highlights a number of digital trade barriers. One might think of what are called local content requirements. So you require that 10% of the media in your country comes from this domestic provider. Well, media is all digital now, so that's a digital trade barrier. Logistics and customs, since all of these products are now being facilitated by the internet, could be digital trade barriers. Intellectual property could be a digital trade barrier if there are very stringent rules on who actually can get a copyright, what their control level is, and if there is referencing and fair use available, those can be digital trade barriers. So they're really, really broad.
I had another question that came in over Twitter that actually drills down on this, I think, a little more, and I don't know the answer to this, and hopefully one or more of you does. Is speed or bandwidth throttling as discrimination part of the trade discussions? I mean, is it just an all or nothing blocking issue, or are we talking about sort of gradation short of that? Anybody know on that, whether that's been included? Usman?
So the Trans-Pacific Partnership, so the U.S.-Korea Free Trade Agreement, which we have text on, has some language that's very close to the Federal Communications Commission's open internet rules, but they are what's called, they're not binding, they're aspirational. So they wouldn't be enforceable in a dispute resolution, but they do talk about this idea of open access and interconnection, which you could reference when you're talking about things like blocking and throttling. But there's never been any trade agreement, as far as I know, that has kind of incorporated the concept of net neutrality and restrictions on throttling and blocking through telecommunications chapter. But the last thing I'll say is there's some interesting trade policy wonks who think that there was when we talked about the Global Agreement on Trade and Services, the GATS, 1994, there was a specific chapter that dealt with telecommunications, and there is language that kind of prevents discrimination in that telecommunications chapter, and so arguably you could use that and kind of go after blocking and throttling of foreign providers using that section of the telecommunications annex, but nobody's ever tested it.
There's a way of looking at that actually from the alternate side also. In one of the elements of Australia's discussions, they had made a briefing on this, and they said the reason we took this position on this element, I don't remember what the element was, is they were concerned about latency. So the idea was that if you had a local service provider, there would be a quicker transmission of the data than if you had a foreign service provider. And so the answer is that is actually not a neutral way of writing that requirement. The neutral way of writing that requirement is this is the level of service you must meet if you wish to provide this service, because that means information has to get from wherever you are to our point in this amount of time. Whether you are in country or out of country is irrelevant. When you say it has to be in country and you use what is a theoretically neutral type of suggestion, that's one of the places where you question whether that motivation was completely exact or not.
Interesting. Other questions from the audience? Sir, yeah.
Sorry, so I'm the one that tweeted in that question.
Oh, you tweeted it.
He's a multitasker.
Definitely not trade, though. I would describe that as local content. Okay.
Rami Cater, I think I'm the only one wearing shorts here. And on top of that, how would one actually go about enforcing that sort of thing? So whether it's from, kind of the flip side or the original, like you had mentioned, does that depend on local authorities since it's internet, since it kind of changes everything? Or how does one even go about it? Because if you are a game provider and latency is a huge issue, you need to make sure you're giving your customers the highest quality of service. If you're any other sort of a provider that's competing with local media services, you have those same issues, whether it's a 10% rule or if it's just, these guys get a better preference that one could argue is strictly based off of location. How would you even enforce it or measure?
So the question is, how does, let's say France has some local content requirement, how does France enforce that?
How would an outside international provider maybe check
Challenge it?
that things are done properly?
So Susan talked about a little bit, but to give more context, there's this body, the World Trade Organization, it has a court. You would bring a challenge. Only countries can bring challenges. So if you were a competing content provider, you would go to your government and say, I'm facing this discrimination in this country. Will you guys bring a case on behalf of our country against that regulation? That case would be brought in this global court, and then there would be arguments, and the judge would decide on which side or the other, and then there would be an appeal process as well that would get played out with a panel of judges, and then once that decision is put in place, as Susan mentioned, then there are options about how to actually enforce it.
Realistically, right, that would be a final option.
Yes.
I mean,
Yeah,
you'd
no.
probably go talk to the French first and see
sure.
if
Yeah,
they might be willing to deal with your concern,
you
right?
don't,
yeah.
you don't necessarily
Yeah.
need to go to WTO because
Yeah.
all these free trade agreements have their own dispute resolution system, which we call investor state dispute resolution system. As an investor in that country, you can sue that government. So you don't really need to go to WTO. You can sue that government, and the government picks their own arbitrator. You put your own arbitrator. These three arbitrators tribunal can decide whether that government is violating its obligations under that free trade agreement. And this has been happening. Like, for example, Eli Lilly, an American pharmaceutical company sued Canadian government, the government of Canada, for invalidating its patents, and claiming $500 million compensation from Canadian government. So you don't really need to go to WTO. If it is in the TPP, if there's a provision in the TPP or TTIP or any other free trade agreement, you just go for the ISDS.
Can I
Yeah, Joe.
I'll go back with just a small reality check.
Yeah, I think that's
Last
a little
option,
broader, but
next
yeah,
to
yeah,
last option, you first go to the country and have a conversation. You
Yeah.
find out if there are like-minded companies. You work through trade associations. You do a lot of things before you get to either of those two options.
Other questions from the audience? Let me throw out one because Susan raised the issue of sort of malware and cybersecurity, and I wanted to pursue that a little more deeply. I mean, one of the things, just as someone who's like all of us in this room, my information is out there with all sorts of companies, and we read quite regularly about hacks of credit cards and things like that. What happens if the information that's being hacked is not stored in the United States? It's in other places. Do I as an individual have any recourse, or if it's corporate information that's somewhere over? I mean, does there need to be some level of at least intergovernmental cooperation on this? I mean, cybersecurity, we're doing a lot more work on it at my organization, the Council on Foreign Relations. Adam Siegel is leading our project there, and there's a lot of stuff going on. I mean, we as an organization are the target of a lot of hacking efforts, and we get warnings from our IT folks all the time. But all of that is very kind of much in the domestic. We control our data, and we're worried about preserving access to it. But what happens if the data is outside of your legal boundaries? Should that be factored into these efforts in some way or another?
No, please. I'll say something.
I mean, there are already actually significant intergovernmental interactions on these things. Across privacy authorities, there's a privacy enforcement network that a number of different privacy authorities participate in, including the FCC in the United States. Security, you have CERTs that are working with each other. You have law enforcement offices that are working with each other when there are investigations about criminal behavior that hit across a number of jurisdictions. You have private sector groups that are also doing some of these things. So there's a lot of cooperation where there's probably a breakdown internationally in some of the more formalized channels, like the mutual legal assistance treaties, the MLATs. Those have not been. Those are considered by most to not be as functional as needed because they don't operate in the kind of real-time methodologies that they need to actually do these investigations. And one of the things we've discovered, though, is that cooperation is beneficial in the sense that often if you see a cyber attack in one geography starting, often there are ways to start thinking about it by the time it gets to the other geographies, because there's been that sharing of information on, hey, we're seeing an attack of this type, and the certs work together on these things, and other places work together. So there is, it's essentially the emergent, certs are also the emergency response teams for these kind of computer incidents. So there is a lot of work going on. Some of the formalized international mechanisms perhaps have not kept pace, but a lot of the kind of points of contact and networks have been working effectively. The problem is when you get to a zero-day exploit, one that kind of has no warning curve associated with it, it's difficult to catch up to it because it kind of hits usually all at once now.
Other comment. I mean, that's so. I mean, in some ways, it'd be hard to formalize this, I would think, because you've got to be very adept to respond to these threats and
You
flexible.
can neither be sedative,
Yeah.
you can neither be sedate nor sedentary.
I think that's one of the problems in these free trade agreements. As I mentioned, we haven't seen the text of the TPP, but we know what's inside TISA. And in TISA, there is a direct obligation for cross-border data transfers. And the thing is, like, it's not very clear what's going to happen, you know, in case of unauthorized or unlawful processing or accidental or destruction of the data. So the answers are not in that text, you know, like when we talk about these issues, we talk about, like, you know, direct obligations, but like we don't really talk about like what if scenarios, you know, like governments will not have any control over the data, and they won't be able to ensure how the data is processed. And Susan mentioned the only exception in TISA, only like specific exception in TISA is national security exception. I mean, there's a general national security exception in GATS. There's a general national security exception in the core text of TISA, but there is another, like a specific exception for e-commerce chapter in TISA, and which is national security exception. It's broad. And the thing is, no one knows what does it mean, but it's there. So I mean, that's our concern. You know, like we talk about exception, we talk about all these things, but you know, if you can propose a national security exception for e-commerce chapter, you can possibly come up with certain exceptions which will assure that the data is protected and processed in accordance to specific guidelines. So.
Excellent. I think we are running out of time here, and I wanted to give each of our panelists just a brief chance to wrap up. I would pose a question, though. You can answer a different one if you want to. We've talked a lot about concerns here. What happens if we get this?
Ted, if I may, we can go till 5 to 1 unless you need to leave.
No. I mean, I'm happy to extend it out, but maybe I'll give each of the panelists a kind of chance to wrap up, which will probably take a. Let me pose a question. You don't have to answer if you want to answer another one. But we've talked a lot about some of the concerns and what happens if we get this wrong. I'd be interested in flipping it. If we get this right, if we come up with a good set of international rules through either trade agreements or trade agreements and other mechanisms, what are the potential benefits here of getting it right? So if you want to tackle that question, great. If you hate my question, you want to wrap up on something else, feel free. Maybe we'll just go down the road here. Usman, do you want to? Or you're frantically looking for something,
Yeah,
so I'll let you go last. I'll start with Susan, and we'll move this way.
Okay, yeah, that's for that one.
Susan, so what are the benefits if we get this right?
No, please, go ahead.
Yeah.
I gotta wing it too.
Yeah, well, there you go.
No,
Sorry.
I actually think it could have huge benefits for access to information and hence the ability of people to act on information. So I think it's unfortunately, this is another catch-22 in that on one hand, if the WTO or other trade agreements which have binding obligations become a venue where information flows and hence the internet is governed, that could have both positive and negative implications for both the WTO's or these other trade agreements intersection with other global tools of internet governance, right? Like, for example, Net Mundial, or the UN, which has just finished language on cybersecurity and the obligations of states related to cybersecurity. So I think, we need to find what is the comparative advantage of putting this in a trade agreement versus putting it in a treaty. Most people in the United States were very leery about having the ITU in any way, shape, or form govern information flows. But I do think at some point we will need to find common ground on rules on it. Otherwise, we might end up with more and more of national intranets. Certainly, we recognize that all governments are going to restrict some information flows. Germany is never going to allow Nazi memorabilia to be sold on eBay. But, whereas in the United States, it's perfectly cool. Israel is not going to allow anti-Semitic comments on Twitter. Should Twitter ban it everywhere? We're going to, at some point, need to come up with some way to ensure interoperability. I'm not sure that trade agreements are the only place or the best place. All I'm saying is, I'm glad we're having this discussion.
Burcu.
Well, I said in the beginning, and I'm going to repeat it, like, you can't negotiate an open internet behind closed doors. And this model is not working. It became clear that it's not working. So, all these agreements, TPP, TTIP, and TISA, they should be debated publicly. And if there, and we need to make sure that there are adequate and express privacy and other safeguards included to these agreements. But the only way to do is to debate it publicly. So, at the end of the day, it's, privacy or the data flows, it's not only the business of business, it's also our businesses. So we have to make sure that our voice is there, and our concerns are heard. And in order to do that, we have to debate it publicly. And I think this is a really great discussion we are having here. I wish there was someone from the government, from the USTR. It would have been interesting to hear their stand on these issues.
Good, thank you. Joe?
Thanks. I think, the potential for successful trade agreements to allow people in markets to benefit from trade is substantial. I think at times I worry that we're overlating trade agreements with obligations that were never meant to be in trade agreements. And we're also looking at trade agreements and ignoring the fact that there are national laws, there are contracts, there are all sorts of other things which are the more logical avenues for redress for many of these issues. There's a very interesting work project going on in APEC, which is that the APEC has something called binding corporate rules. Cross-border privacy rules, which is their version of kind of a pact across all the APEC nations of what set of rules would allow you to transfer information while respecting privacy. The European Union has something called binding corporate rules, their version of the same thing. Theirs came before the CBPRs did. And the concept is there's a work group going on where members of privacy authorities from the EU are participating with the APEC data privacy subgroup that's responsible for drafting the CBPRs, and they're trying to figure out what is the commonality between these two sets of rules and how might they interoperate, which is the concept of allowing the good to win over the perfect. Because the answer is if you wait for the harmonization between those two sets of rules, it's not going to happen. But if you wait and figure out that, there's probably about a 70% overlap in the obligations, and if you allow people to take advantage of the fact that if I've already done this 70%, how can you give me credit for it? Or if you develop a combined application form for both of them so that you do something once and you get benefits twice, those are kind of some of the secret sauce. And those are things that can terribly well supplement trade agreements and make the working pieces work better together. So let's not think the trade agreement is the place to park all the baggage. But the concept of where you have a distortion in trade because flows that might happen in trade otherwise are prevented, that is the purview of a trade agreement to deal with. And I think we just need to figure out what is useful to do there. The other issues that aren't in there aren't irrelevant, but that just may not be the place to deal with them.
Excellent. And Usman, you have the first word. I'm going to give you the last word.
Thank you. And I'm going to reference the United States International Trade Commission again, because they answer your exact question: what is the effect of removing barriers on the U.S. real GDP? So that's what I was looking for. And they estimate.
The ITC's work is great, by
Yes,
the way. I
they
commend them
estimate 16 billion to 40 billion in increase to the U.S. GDP from removing the barriers that they identify. But I would also just, again, couch that with the idea of it's a whole breadth of businesses that would never have had access. It's a whole breadth of consumers that would never have had access. And it's not just the U.S. I mean, we can get global for a second. Like, a lot of these issues are in the developing world, and there's a huge potential growth opportunity for them if some of these barriers are removed. And the last thing I want to say is on trade as a venue. While I agree completely that it's not the right venue for everything, it has a very narrow purview for what I think the internet is trying to accomplish, which is to create a global network for communications. It's a really good vehicle. It's a vehicle that's designed to remove national borders and barriers, and that's what the internet has done. It has removed national telecommunications barriers and kind of enabled people to connect very easily across borders. And trade, I think, in many contexts, is trying to do the same thing. And the last thing I'll say is, a lot of digital communications get stopped for other reasons. We've talked a bit about intellectual property. You might be able to send your video that you've made on YouTube to somebody in the UK, but if it's violative of the UK's intellectual property law, which is somehow different than ours, then all of a sudden you're in trouble. So a trade agreement could help to harmonize those rules, to create a standard that actually makes sense for the future. The question is the substance, and like, will it actually do it?
Fabulous. That's a good note to finish on. I would also like to thank my research associate, Rob Maxim, for helping me not make an idiot of myself in this forum. And let's thank our panelists for a tremendous discussion. Appreciate it.
Thank you, Ted. Thank you, everyone.
Thank you.
Thanks.
Joe,
Very interesting.
thank you for the correction. You're absolutely right. Here's where I don't see.
Hello, how are you? Good to see you. Good. How's the project? How's the work?
started working with Michael yesterday.
Oh, good.
It is.
Okay.
It is. It's a
Wow.
fundamental
So you're
work
directly
against
on
government,
this.
not against
Nice.
Yeah.
Very cool.
And so we haven't really thought about it in the same way that, let's say, the
These mics are
and I'm not
hot, by
saying
the
we
way.
should, but your point about it being about how governments behave differently that's right. That's a very, very important.
I'm Molly McPherson with
When
Access
I
Partnership.
had
I just want to introduce myself. I think you know my
their
colleague from
lives,
Burcu.
Yeah.
you don't see it. You don't share the same
Yeah, he
knowledge
should be here
in
somewhere.
defining privacy. And I'll give you one more example, if I may.
So I just recently moved over to Australia.
The U.S. government defines privacy as a trade barrier when it's inadequate, and defines privacy as a trade barrier when it's too strong. So what is it?
Yeah.
Still taking shape.
Speak to the
I mean, the company hasn't even launched it.
the FTC.
So are you focused on a trade?
Yes, that's right.